Sir, would you please state and spell your name for the record?
It's Grant Dorfman, G-R-A-N-T. Dorfman is D-O-R, F as in Frank, M-A-N.
Okay, and I understand you were a judge, but just to keep the record clear, I'm going to call you Mr. Dorfman if that's all right.
I appreciate that.
Okay. Mr. Dorfman, could you please tell these senators how you're currently employed?
I'm the Deputy First Assistant at the Office of the Attorney General.
Okay. And I'm going to ask that you lean into that mic and speak loud and clear so that everybody in the courtroom can hear you. Now, before we talk about your role as the Deputy First Assistant, I want to talk to you a little bit about your background and who you are. Can you tell us where you're from?
Grew up in Dallas, Texas.
Okay. And where did you end up going to school?
Brown University in Providence, Rhode Island.
Okay. And then, was that for undergraduate?
Sorry?
Undergraduate?
That was my undergraduate, yes.
Did you go on to do law school?
I did.
Okay. Can you tell us where you went?
Yale Law School.
And what did you do after you completed your time at Yale?
I accepted a clerkship with a federal judge in Houston, Texas, brought me back to Texas after 10 years on the East Coast. I also took 2 years out before law school, got a graduate degree there, not in England as well, and then had a 1-year clerkship opportunity in Houston. Thought I was going back to D.C. to join the Department of Justice for the second term of the George Herbert Walker Bush administration. That never materialized, so I ended up blessedly staying in Houston.
Okay, so after that didn't work out, what did you end up doing next?
I went to work for a commercial litigation boutique and continued in that line. Went to a second firm where I made partner in, I think, 1999.
Okay, which firm was that?
Ogden, Gibson, White & Brooks, and the first firm was Sussman Godfrey.
Okay, and while you were working as a partner, can you describe to us kind of what type of law you were practicing?
Commercial litigation, generally that's a big area, but civil trial work and appeals, and a lot of energy work, a lot of employment cases, and just the things that Houston trial practice is made out of.
Understandable. What did you do after you spent your time working as a partner at the law firm?
Well, I had a desire for government service. I'd never really set it out to be a partner at a law firm and continue that for the last 30 or 40 years of my career. So I'd applied to the Department of Justice when the George W. Bush administration came around, went up to interview for 2 vacancies in deputy AGs in the civil division. I ended up withdrawing within 1 week of the interview because my daughter was on the autism spectrum disorder. She was then 4 or 5 years old. And it turns out, to my surprise, but after exhaustive research, the school she was in Houston did not have any counterpart, any comparable service in either the Washington or Baltimore metro area. So I had to withdraw from consideration for that. That lit a fire under me, reminding me that's kind of what drew me to the law in the first place. Okay. And so...
let me stop you real quick. So that's back to Houston, right?
I'm still in Houston.
Okay.
Never left. But then I put in for an application to Governor Perry's office for 2 district court vacancies in 2002.
Okay. And can you tell us what happened with that application?
It was successful.
Okay.
I was appointed to the 129th District Court in Harris County. It's a civil district court in May of 2002.
Okay. And can you tell us what happened after that term and farther on in your career?
I'm sorry, I didn't catch that last part.
After you served as a judge, a civil court judge in Houston, what did you do next in your career?
Oh, well, involuntarily, the voters decided in 2008 that they liked President Obama better than the rest of the ticket. I went in-house with Neighbors Drilling as an independent oil and gas contractor, I should say, with worldwide operations based out of Houston with about 25,000 employees, and managed their civil all their litigation.
Okay. And then at any point did you serve another term as a judge in Houston?
Got remarried in 2013, wanted to do something different, and reapplied to Governor Perry for a district court bench, and was appointed in November 2013 to the 334th District Court, also in Harris County, same kind of court I'd presided over before.
Okay. And so in total, about how long did you serve as a judge?
I think altogether 10 years,
okay,
not including visiting judge service afterwards.
Okay. And then at some point, you become Deputy First Assistant at the Attorney General's office. Can you talk to us about what took you from Houston to Austin for that job?
Not to dwell on bad news, but in 2016, I, along with most of my Republican colleagues on the bench in Harris County, lost. And I went back in private practice for a couple years. My father passed in that time frame, and I stepped into a family business that needed more care than I could give it as a full-time litigator. So I juggled that with having left the law firm, being a mediator, an arbitrator, available to parties to resolve their disputes, and also a visiting judge when the administrative presiding judge in Houston appointed me to service in that capacity.
Okay. So what brings you to the Attorney General's office then? How do you go about applying for that job?
Well, it came sort of out of the blue. I had a call from my friend Austin Kinghorn, who I'd known for several years as a law clerk to one of the justices on the Supreme Court, before that on the Court of Appeals. And he asked if I knew anyone who might be interested in working for the Attorney General. And I said, yeah, me.
Okay. I want to talk to you about that. It's no surprise we're here because there have been a lot of allegations made against Attorney General Paxton. You're aware of this, I assume?
Sure.
So when you get that call from Austin Kinghorn, you're interested in the job. Were you aware of all these allegations at the time?
Yes.
Okay. And can you talk to us a little bit about how you became aware of what was going on?
News reports, as probably most others did.
Was that concerning for you?
Yes, it was.
Can you talk to us a little bit about the concerns that you had after reading the news reports?
Well, I knew the reason they were calling and looking for people was because they had openings, and that was the good news. The bad news was these were serious allegations, serious charges that concerned me. And when I did go up to interview in Austin, and for that reason, probably unlike any other interview I've had, I took special time to press, in this case, First Assistant Brent Webster, on these charges.
What were your main...
Normally the interviewee is the one trying to sell him or herself.
You had to cross your T's and dot your I's. Can you talk to us about what your main concerns were coming into the Office of Attorney General?
You might be less interested in this, but I had kids at the time in high school and in junior high. So commuting back and forth to work was a concern. Where to live in Austin, it's not cheap, was a concern as well. So those were, I think you're asking something else.
Well, that's a fair concern, but I am also interested, like legally speaking, you're walking into an office where the Attorney General himself there have been allegations made to the FBI.
Sure.
And so what about that was specifically concerning to you in that situation?
Well, as I said, I spoke with Brent Webster when I interviewed, and I was much more pointed and brusque than I would normally be when I'm trying to get the job. And I knew he was a prosecutor, and by all accounts, a good one. So I pulled no punches. I pressed him, asked what I thought were fairly pointed, direct questions as to, okay, this is the allegations I'm seeing in the paper. What's the answer to that?
Kind of like a cross-examination a little bit?
A little bit. And it had an evidentiary quality to it as well, because he very patiently, I thought, given the busy nature of the office and the constraints he was under, took the time with me to walk me through the documents he'd assembled at that point.
Okay. Now, after leaving that conversation, can you talk to us about what your opinion was with regard to taking the job as Deputy First Assistant Attorney General?
Well, I satisfied myself that these charges were, in my opinion then, not well-founded. I knew as part of my job there were a number of interesting things going on in the office, but I also knew as part of that, like the Google ad tech lawsuit was coming. In addition to that, I'd be in charge of defending, I think it was then pending, the Whistleblower Act lawsuit involving these charges. So that was also a concern.
Right. So I assume you take the job because we're here right now.
I did.
All right. And I want to talk to you about, well, when exactly was it that you started as the Deputy First Assistant?
December 3, 2020.
Okay. So that's after everything kind of went down with regard to October and the reports to the FBI, right?
Yes.
You mentioned that you were a part of ultimately the whistleblower suit. Are you aware of reports that were drafted within the office?
Yes.
How many reports were there?
2.
Can you distinguish the two different reports that were drafted on behalf of the Office of Attorney General?
Yes, the first one started almost from the time I was there. The first I remember seeing a draft was sometime in January, I think early January, because I was still working from home right after the holiday. I remember that going through edits of 2021. And that was released by our office in August of 2021, publicly on our website.
Okay.
And that detailed the main whistleblower allegations and what our office, after forensically collecting documents, emails, exhaustively compiling everything, was able to put together to address these allegations.
And can you tell us who actually authored or published that report?
The Office of the Attorney General.
Okay. Now, is it safe to call that the internal report?
Yes.
Was there a secondary report that was drafted?
Yes, and if you have a copy, that would help me be clear and precise, but I believe it is on Louis Brisbois' letterhead or in the format of a memo to the Office of the Attorney General.
Objection, Your Honor. Testifying from a document not in evidence, testifying about a document not in evidence, and hearsay.
Thank you.
Sustained.
There's a report in existence, correct?
Same objection, Your Honor.
There are two reports.
He's not testifying with regard to what is stated in the document.
Overrule that. Go ahead.
Okay. There is an existence of a Louis Brisbois report, correct?
Yes.
All right, we'll get there. But before we do, I want to be very clear. You started in December of 2020, right?
Yes.
You've looked at both of these reports, the internal report and the Louis Brisbois report, right?
Objection leading, Your Honor.
Show only to lay a foundation, Judge.
I'm going to sustain, just,
Yes, Judge.
ask the questions one at a time.
Certainly. Are you aware of...
It's hard for me not to rule, by the way.
Are you aware? It's in their allegation, so I'll talk about it. Are you aware of the two reports?
Yes.
Have you read the two reports?
Yes.
Now, were you present at the Office of Attorney General during any of the subject matter involved in those reports?
I want to answer no, and I think that's right, but I would have to look at the reports to absolutely confirm. But I think everything that was detailed in both reports predates December of 2020.
Sure. Well, let me be more specific. Are you aware that the Office of Attorney General was involved in an open records request involving Nepal?
Historically, I'm aware. I wasn't there at the time.
Are you aware that they were involved in litigation with the Mitty Foundation?
Yes, again, historically.
Are you aware that there was an informal guidance letter with regard to non-judicial foreclosures?
Yes.
Now, were you present at the office during any of those events?
No.
Were you present at the office during the hiring of Brandon Kamek?
No.
So is it safe to say that you don't have personal knowledge of any of those events that are authored in the reports?
Yes.
All right. Give me one sec, Judge. I intend to get an exhibit for the witness. Copy for the court. Thank you. Mr. Dorfman, would you take a second to look at a copy of my exhibit numbers cut off? Attorney General Exhibit 23, and let me know whether you recognize the document.
I have looked at it and I do recognize it.
What is this document?
This is what you're referring to as referred to as the Louis Brisbois report, the second report in time that our office released on these matters. Well, I say our office, this was outside counsel sending it to the office.
Okay. And is this a fair and accurate copy of the report issued by Louis Brisbois on behalf of the Office of Attorney General?
Near as I can tell.
At this time, Judge, I would offer Attorney General Exhibit 23.
Your Honor, there's so much hearsay in there, I don't know where to begin. The document itself is hearsay. Within this document are conversations between people that are out of court statements that are hearsay. It relies on documents that are out of court statements that are hearsay. It also relies on people talking to other people who talk to other people, which is 3 layers of hearsay. So my objection, Your Honor, is hearsay squared.
Sustained.
Judge, may I respond briefly? My understanding, and Mr. Arroyo, if you would pull up Article 7, please. My understanding is that the House Board of Managers allegation in this case is that Ken Paxton and the Office of Attorney General issued a report that basically alleged false and misleading facts. This is a legally operative document in this case.
Your Honor, may I respond?
And the House doesn't want it in evidence? I don't understand how they can argue it's a lie if it's not even in evidence before the jury.
Your Honor, I hope counsel is not trying to mislead this court, because this article of impeachment is based on the internal AG report. This report, the Lewis-Brisboe report, came out after the article of impeachment. And so I'm sure counsel would like to retract his statement and not mislead this court. Regardless, this is so much levels of hearsay, and this thing up on the screen doesn't get around that.
I don't wish to retract my statement at all. I don't think that the allegation is necessarily clear, and I'm going to continue to argue that this is a legally operative fact.
I would suggest as an officer of the court that he retract it, because this report has nothing to do with this article.
Come forward, gentlemen.
Thank you, Your Honor.
For the record, I had sustained that objection, and it stands. Go ahead.
May I proceed, Judge?
Pardon?
May I proceed?
You may proceed.
Okay.
Hold on 1 second. Our jurors left the building for a moment. I did not notice. Give a senator a minute, and they're gone. We will be taking a break shortly, members, okay? We've just been back 90 minutes, and we normally take a break between 90 minutes and a little bit more. I think we're still missing a few. That was a short meeting at the bench compared to other ones, so they were basing their exit on their experience here the last 2 weeks.
I could tell where it was going, so.
Good news is the cricket also left the chamber.
I just think we're more entertaining, Mr. Dorfman and I, so cricket's out of here.
I believe all are present and accounted for. You may proceed.
Thank you, Judge. Before we talk about the internal report, I want to talk to you about your time at the Office of Attorney General in December of 2020. Can you talk to us about what was going on as far as it relates to productivity in the office at that time?
It was a very busy time. I think I mentioned the Google ad tech lawsuit that had been years, as I understood it, in the making. We were about to release the complaint at long last in federal court. It was a huge and extraordinarily complex case. You're taking on Google, so I was told if I took the job, I would have frontline responsibility for, or at least overseeing that, and we intended to hire outside counsel. So that was a big part of that. At the time, of course, the election was still going on. There were still election challenges, and I know people were talking to the office about that. That ended up resulting in the Texas versus Pennsylvania lawsuit. So my first week on the job, I think my first day on the job, we went to lunch.
I'm going to slow you down. I'm going to break that up, Mr. Dorfman. So you're talking about the election. I assume it's the presidential election, correct?
Yes.
Okay. And can you talk about the effect that that had on the workload of the Office of Attorney General at the very beginning of 2021?
Well, I had nothing to gauge it by, but it was extraordinarily busy time.
And did it appear that the morale, that people were working hard at the Office of Attorney General?
Oh, absolutely.
And despite the allegations that were made against Attorney General Paxton, people were still working at the office?
Yes, in my first 2 weeks there, I don't think I made it home before 8 p.m., certainly.
Did you have any, sorry to cut you off, but did you have any concerns about the work pace and workflow at the office?
No, it was fun. I mean, if that had been for the next 2 years, I would have had concerns.
Okay. As far as burnout goes or things like that, were there any concerns about anything like that?
Specifically December 2020?
More into 2021.
Yes, as 2021 went on, obviously the Biden administration came into office. Day one, people may remember this, a raft of executive orders. We were the first, and I'm proud of this, we were the first state attorney general's office to obtain a preliminary injunction against one of those executive orders. It was the day one immigration order that imposed a 100-day moratorium on deportations, even where congressional statute dictated that removal must take place of a deportable alien within 90 days. And so we challenged that in court, federal court here in Texas, and won. And of course, there were other executive orders that we were challenging and filing lawsuits against. I was a voice in the office from a beginning then, but throughout this time, and as we continue to do the work, that look, it's great to be in court. It's great for our lawyers to go into court at the daytime and spend the whole day and file briefs at night, but you can only do that pace for so long. So I wanted us to be careful, husband our resources, use them wisely, pick the right cases, prioritize appropriately.
Utilize your resources.
To maximize the good work we were doing, okay. I thought.
Now, during that time in fall of 2020, winter 2020, and into spring of 2021, are you guys working in the office or are you working at home at this point? Or is it a mix?
Where I was, everyone was in the office. Now, some of the attorneys in the divisions, the litigation divisions, did a combination.
Okay.
In a lot of the cases, the courts were shut down due to COVID still in many cases. So even though we had cases all over the state, you might have a hearing in San Antonio on this computer in your office, then you turn and have a Zoom hearing in Midland or El Paso 30 minutes later.
Understood. And
which helped, less travel.
Right. You said that you were Deputy First Assistant Attorney General. Are you aware of who your predecessor in that position was?
I believe it was Ryan Bankert.
Okay. Can you talk to us about your role at the time as the Deputy First Assistant Attorney General?
The core responsibility I had is to oversee the litigating divisions, both criminal and civil. As I'm not a criminal lawyer, never have been, never was a criminal judge for that matter, I rely very heavily on my criminal division deputy, it's Josh Reno, and to manage those responsibilities and report up to me and as needed. But the civil litigation divisions, I feel very comfortable overseeing them. In addition to that, I have overall responsibility at the executive level for policies, procedures. From time to time, I've also had direct report responsibility over human resources, as I do currently, and also over the communications team.
So a wide array of divisions.
Yes.
Now, are you familiar with whether at any point special litigation was under the oversight of your position, Deputy First Assistant Attorney General?
I don't think it has been since I've been there. I think it was at one time. Again, I don't know this personally.
And can you tell us now who oversees the Special Litigation Division?
Ralph Molina.
Okay. And then under Ralph Molina, or at any point in time, was it a Patrick Sweeten?
Yes.
Is he still working that position, moved to a different position?
He's currently our lead counsel in the Buoys case in the Rio Grande River, but that's on loan from the governor's office.
Did you have the occasion of working at the Office of Attorney General while he was in charge of special litigation?
Absolutely, yeah. I mean, until I think earlier this year, he joined the governor's office. Up till that point, he was there the entire time I was there.
Okay. Did you feel like you had to help him with his job, or did he appear to be qualified in handling his business in that position?
Patrick?
Patrick.
Very talented lawyer, very experienced, very capable. If I had one criticism of him, it's that he's in court more and managing less. We wanted him to clone Patrick Sweetens, so we had a team of Patrick Sweetens, but Patrick's so good and so natural in the courtroom, I think he longed to be there.
Okay. Do you feel that Patrick is the kind of guy that takes pressure off you if you didn't have to watch the Special Litigation Division?
Certainly. They're the Special Litigation Division for a reason. I think that was a creation of Attorney General Abbott to have the tip of the spear. We have a lot of litigating divisions. We have our General Litigation Division, which are outstanding. All our divisions are very good, do different things. And special litigation is you need to be at the courthouse in 30 minutes. We just found out the Obama administration's filed doing this. They've issued that executive order. No time, let's go.
Okay.
And so if I had to oversee that as well as everything else, you're right, it would put more pressure on me.
I want to fast forward and talk to you about the internal investigation report. You said you had no personal knowledge of the contents or the subject matter of that report, right?
Say that again, please.
You had no personal knowledge. You weren't personally there for the subject matter that is in the internal report authored by the Office of Attorney General.
I wasn't there at the time these events happened.
Were you present at the Office of Attorney General when the report was being drafted?
Yes.
Can you talk to us about who was responsible for that, and if you know what process went into drafting that report?
I think in the first instance, we relied on an office-wide forensic compilation of documents, emails, et cetera, that were relevant. Brent Webster took the lead in compiling that. And then we had a team, and again, as early as January, I was editing drafts with others, Josh Reno, later Murtaza Sudarwala, our deputy for legal policy, Austin Kinghorn, Enrique Varela. There were others, but I may have left them out.
Okay. And can you talk to us about what your role was with regard to the publishing of that report, or at least getting the report ready to be published?
Well, I don't think we published it until August of 2021, and that probably is a reflection, one, of just how busy the office was and how much other stuff there was to attend to. But I'm sure I had revised and edited and redlined at least 5 or 6 times the entire document front to back.
Okay. Now, understandably...
and others did as well.
Right. Understandably, you weren't present for these events that the document summarizes. Did you play a hand in trying to find documentation to support the positions taken in that report?
More oversaw that process.
Can you talk to us about your oversight of that process?
Yeah, I felt very strongly this had to be, it was going out as a report of the office. I believe the Attorney General had said, look, these allegations are baseless, and I will investigate and present the facts and let the voters decide. Words to that effect. I wasn't there. And so this was a fulfillment of that commitment. I took that as a charge to lay it out there. And I think it's fair to say that the document, my emphasis throughout this process of editing was, look, this needs to be the voice of the agency. It's not any one person. It's all of us, and it's objective. It's factual, both in tone and substance. If we make a conclusion or from the facts that we presented from the documents that isn't supported by the document, let's not make that conclusion. Let's take that out and let the people reading it make their own decisions.
And so really, you're just trying to make sure that they're not making allegations that they can't back up.
Objection, leading.
Sustained.
Would you agree that your job was to make sure that the claims were verified?
Same objection, Your Honor.
Sure. Was it your job to make sure that there was evidence or at least something to corroborate statements that were made?
Was there an objection there?
Not to that, Your Honor.
I didn't think so. Okay.
I certainly viewed that as my job, yes.
All right. Now, you mentioned earlier that at some point you get involved into the lawsuit in this case, and I want to talk to you about the lawsuit, okay? Can you tell us your understanding of when the whistleblower lawsuit was first filed against the Office of Attorney General?
I think it was November of 2020.
Okay. Can you tell us who the named parties within that lawsuit are?
Going to struggle on their first names.
No problem.
Ryan Vassar.
Okay.
Mr. Maxwell's first name is
David Maxwell.
David Maxwell. Thank
right.
you.
Mark Penley, ring a bell?
Mark Penley and Blake Brickman. Sorry.
Okay. And more focused on who is the named party or the named defendant in that lawsuit?
There's just one defendant, the Office of the Attorney General.
Okay. Was Ken Paxton specifically named as the party to the lawsuit?
No.
All right. So it's the Office of Attorney General on the filing.
Yes.
And what is the first thing that you all do? Who all is working on the lawsuit with you at this time?
About the same time I was interviewing, I think they were interviewing for outside counsel, so I knew Louis Brisbois had been hired, and either the first or second week we might have had a phone conference or meeting with them. At that point, I think the lawsuit had been amended at least once. There was later a second amended, and so I was working on it. Austin Kinghorn was working on it. The first assistant would have been involved.
How about Chris Hilton? Was he working on it?
I think that's right. I think Chris Hilton was also from the start there. He certainly was later.
Sure.
Enrique Varela as well, who worked with Austin Kinghorn.
And I'm going to cut you off. You mentioned Louis Brisbois. Can you explain to us what Louis Brisbois' job was with regard to the whistleblower lawsuit against the Office of Attorney General?
To be outside counsel, Bill Helfand is an attorney I've known in Houston for at least 20 years. Very good lawyer, specializing in government work, especially defense like Section 1983, federal court lawsuits, many of which, if not most, have an employment quality to them. The sheriff being sued by his deputy, something like that.
And just without getting into the contents of the document that I showed you earlier, the Louis Brisbois report, was that authored by the attorneys that were outside counsel for the Office of Attorney General?
Yes, Mr. Helfand and others.
Okay. Now, in that litigation, did you all file a plea to the jurisdiction?
Yes, we did.
Okay. Can you explain to us what a plea to jurisdiction is?
A plea to the jurisdiction is a document that says to the court, every court must first assess whether it has,
Speaking of the microphone.
Every court must first assess, that was too loud, whether it has jurisdiction to entertain a lawsuit. And the state of Texas cannot be sued for money damages without its consent. And this body and the House are the ones that must expressly waive by statute the immunity from lawsuit, the sovereign immunity of the state of Texas, in order for a plaintiff to recover money damages. They argued, the plaintiffs in this case, that
I'm going to stop you and I'm going to break that down. You know, I didn't go to Yale, so you got to make it slow for me. Mr. Arroyo, would you please put up Article 8 onto the overhead screen? So essentially, plea to jurisdiction, well, let me ask you this. Is that something that is commonly filed in lawsuits in your experience as a civil litigator? Or at least with regard to Office of the Attorney General?
I was going to say, at the Office of the Attorney General, I'd say probably 90% of our defensive cases, at least the ones I'm most familiar with, we file a plea to the jurisdiction. Almost every case challenging the most recent enactments of the legislature arising out of the last session, which have been, all those legal challenges have been brought in the last few months. We filed pleas of jurisdiction, I think, in every one of those, saying this suit can't go forward, the court has no jurisdiction, the state is immune.
Okay. Now, Eric, if you could just blow up the second paragraph specifically all the way down to, well, this part's fine right here. If you could blow that up. Okay, so I'm just going to read the Article 8 to you, Mr. Dorfman, which states that specifically Paxton entered into a settlement agreement with whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of the facts. The next page goes on to say, and testimony at trial to Paxton's advantage. Sorry.
Let it get up on the screen.
Yep.
Okay, continue.
To Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. So at what time we know that the lawsuit was filed in November of 2020. When was it that the Office of Attorney General actually files the plea to jurisdiction?
Not exactly sure, but I believe it was January of 2021.
Okay. And when did the Office of Attorney General engage in settlement agreements with the whistleblower plaintiffs in this case?
Almost exactly 2 years later.
Okay. So when we're talking about the plea to jurisdiction, we are 2 years before settlement discussions even come into play, right?
Right.
Now, I think in your motion for plea to jurisdiction, it was in two parts, correct?
I'd have to see it.
Well, did you talk about sovereign immunity?
Absolutely.
Can you explain to us how sovereign immunity comes into play in your plea to jurisdiction?
Well, I think I've covered that. The state is immune from suit unless there's an express statutory waiver from the legislature.
Okay. And then the second part of that was that you talked about separation of powers.
Yes.
Can you talk about that to us?
Well, let me go back and cover the first one, if you don't mind. May I, Your Honor?
If you'd please go back and cover
I need to qualify my comments. What you're describing is, you've reminded me and refreshed my memory that the Whistleblower Act is exactly the type of express statutory waiver of sovereign immunity that allows one to sue the state, in this case for money damages. But the case law has been clear, and we argued it, that unless you meet all the elements of a Whistleblower Act claim, there is no waiver of sovereign immunity. There's no jurisdiction for the court to proceed. And we alleged that the plaintiffs in the case had not met their burden of establishing all the elements of the whistleblower claim, and therefore sovereign immunity still applied.
Okay. And was that file in the plea to jurisdiction, was that made in good faith and based on your legal research?
Yes.
All right. Now I want to focus back onto the article that states specifically, if you'd go back to the other page, Eric. It talks about, and you zoom in, the settlement agreement stayed the wrongful termination suit. I just want to be clear, when you all filed the plea to jurisdiction, that had nothing to do with the settlement agreement, right?
We weren't even discussing settlement at that time, no.
Okay. Now, what is the result of a plea to jurisdiction with regard to discovery in a lawsuit?
The plea to jurisdiction, again, every court must first assess whether it has jurisdiction. If it doesn't, it's powerless to order discovery or proceed any further. And the legislature has passed an interlocutory appeal so that even if we lose the plea to jurisdiction, if we win, the case is over and dismissed. If we lose the plea to jurisdiction, we have the right to immediately appeal, when normally you would have to wait till the end of a case to file your appeals. And the intermediate appeal stays the court's jurisdiction. It can't proceed further in any capacity until the appeal is resolved.
Okay. Now, was that plea to jurisdiction filed to stop the discovery getting out to the public in this case?
I don't understand your question.
You just said that a plea to jurisdiction essentially stops the discovery from occurring in a lawsuit, right?
It stops anything from occurring in the trial court.
So my question to you is, when you all filed the plea to jurisdiction, did you do so because you felt that the law applied in that situation, or did you do so because you wanted to stop discovery from getting out to the public?
We did it because we thought the state had sovereign immunity, and it was our duty to assert that, as we do in so many of our cases. That does have the effect of stopping discovery from going forward and saving the taxpayers the expense of that discovery, and our lawyers, the time that, discovery really is where the time gets taken in trial cases.
Okay. I want to talk to you about the procedural posture of the plea to jurisdiction. Can you talk to us about the first court that ultimately ruled on you all's plea to jurisdiction in the whistleblower lawsuit?
The first court?
Yes.
That was the Third Court of Appeals here in Austin.
Well, did it go to the district court prior to that filing?
I'm sorry. Yes, you're right.
Can you talk to us about that?
We had some discussions back and forth. I don't know how much detail you want to go into, but with the plaintiff's attorneys about scheduling a hearing on two things. They wanted to have a temporary injunction hearing. I think initially they said they needed 4 days. The only purpose of a temporary injunction hearing in this context would be for Mr. Maxwell and Mr. Vassar to seek reinstatement under the Whistleblower Act. So to be reinstated to their position with the Office of the Attorney General.
So are you saying that Mr. Maxwell and Mr. Vassar actually wanted to come back to the Office of Attorney General?
Yes, and I think that's still in their live pleading. Well, they're pleading, I shouldn't say live.
Right. Now, what was the ultimate decision by the district court with regard to that plea to jurisdiction?
Well, so we were trying to schedule the plea to jurisdiction before, 1 week before, something, 1 day, whatever, because the court can't have a temporary injunction hearing until it's heard and ruled on the plea to jurisdiction. The plaintiffs requested and the court agreed to set them on the same day, but that had the effect of meaning before the judge ruled, we were set to a temporary injunction hearing, which got underway and started. And there was even testimony taken, I think, from Mr. Mateer for some time before we got the Court of Appeals to agree that by proceeding with the temporary injunction, she'd implicitly ruled, the judge had implicitly ruled that she had jurisdiction. And
so ultimately, and I'm going to cut you off, ultimately the case goes up to the Third Court of Appeals?
Yes.
Okay. So the district court didn't rule on the plea to jurisdiction necessarily?
I'd have to go back and check. I think she may have written an order expressly denying it, but not until after we had already gone up to the third court and said, we need intervention.
Okay. And can you talk to us about what happened at the Third Court of Appeals?
They said oral argument, and I can't remember exactly when that was, but I believe it was October of 2021 when they issued their opinion, maybe 30 pages.
So almost a year later, while that plea to jurisdiction is still pending, right?
Well, the plea would have been filed in January, I think, and so you're talking 9 months later.
Okay. And can you tell us how the court ruled, the Third Court of Appeals ruled?
The Third Court of Appeals agreed with the plaintiffs that the trial court had jurisdiction, that our reading of the Whistleblower Act on the two prongs you mentioned was wrong. Well, they disagreed with it.
Okay. And in response to the Third Court of Appeals ruling in that case, what did you all do on behalf of the Office of Attorney General?
We appealed that to the Supreme Court of Texas by filing a petition for review, asking them to take the case and reverse the Third Court's ruling.
Okay. Now, do you recall when the appeal to the Supreme Court of Texas was filed?
Not exactly. It would have been within 30 days, maybe 45 of that October, I think 2021 opinion from the Third Court.
Okay. And at this point in time, what is going on with the litigation in the whistleblower lawsuit?
Only the appeals process.
Counsel, excuse me, I'd promised a break about 15 minutes ago for the jurors. They've been in a 2-hour sit down.
Now's an okay time to stop.
Is this a good time?
Sure.
I don't want to interrupt, but it's a good time. Members, it's 5 minutes before 4. Come back at 4:15, 20-minute break.
Okay, so Deandra,
We'll stand at ease.
is this helping?
I don't even know what this guy's doing. I mean, I guess they're trying to show that there was no intentional delaying of the court case to impact the election.
Right.
I don't know. It's pretty dull.
Yeah, we had testimony from one of the whistleblowers that talked. Oh, that was Brickman. It was Brickman. Yesterday we had testimony from Blake Brickman, talking about how when the Attorney General's office argued that the Attorney General was not subject to the Whistleblower Act, that stopped discovery. So they seem to be, like you said, making this argument that the stoppage of discovery, that it was coincidental that it happened to coincide ultimately with an election, and then they, after the election, decided to enter into settlement negotiations.
Big settlement negotiations, big money.
$3.3 million worth.
Well, you know, I've learned throughout this trial that there are no coincidences in Austin, so I'm just going to go with that. Learned a lot of lessons in this trial. I've learned don't ever go to Starbucks with Ken Paxton. I've learned this whole thing about coincidences in Austin. So I'm sure that it had nothing to do with the election.
So when they get him on cross, if you were cross-examining him, what would you do?
Probably I'd start out with the fact that this guy made some statements thinking that all these firings were justified when he has no personal knowledge about any of this. I mean, he didn't even come on board, I think he said, to what, December?
Yeah, it was
of
later
that
on.
year.
It was
So,
after pretty much everything had happened.
I don't know. First there's that, and then he was talking about how busy they were with Google, and then somehow he's got all this knowledge about this. I don't know. I'd kind of go after his knowledge base and what conversations were going on as far as their decisions to fight this thing and then suddenly cave as soon as the election's over and decide they're offering $3.3 million.
Well, he said he oversaw the drafting of the report, and he said that he wanted it to be, quote, the voice of the agency and to be factual both in tone and substance.
Well, I wonder if he interviewed any of the whistleblowers before he got his factual in tone and substance report.
I don't know. They'd all, at that point, they had all been quit, resigned.
I'm sure they
fired.
had phones. Could have called them. Could have called their lawyer. Asked for their side of the story. I mean, these guys. But, you know, he seems like a nice enough guy. I mean, he's, I'm not sure why he's here, I guess is it.
The only thing I can figure is just that he's there to rebut the claim from Blake Brickman that that the timing of the settlement negotiations had to do with the election. That's the only thing that makes sense right now.
Yeah, it's just all coincidental that it all happened at the same time. I'm going with that. It's working for me.
Okay.
What do you think, Bud?
Well, the interesting thing I thought was the little kerfuffle with OSO over what was admissible and which report they could use, and you know, it seemed like that the defense got slam dunked on.
Len Dutko called it hearsay squared.
That's right.
Yeah, that was good. I've never heard that before, but it was a really good
The hearsay
description.
inside the hearsay inside the hearsay.
about hearsay. So.
Yeah.
You going to try using that sometime?
I actually may steal that. He was very good. He was very good. I liked his cross on these people. I don't know if he's doing it on this next one, but he's very good.
I would assume he is, because he's the one. So far, whoever's doing the objections is the one that then does the cross.
Well,
So.
I think he's excellent. I wish we'd heard a little bit more of him before today.
Well, we're seeing some really good lawyering, I think, from some of the from Aaron Epley and Mark Donnelly and Dutko, who we've not heard from before today. And I was telling someone, I feel like we've got a new legal legend in Aaron Epley, because she's pretty good.
Now, I thought Allison Collins did a good job this morning on the defense side.
She did.
She has a very nice way about her.
A good demeanor.
She has very nice demeanor. I thought she did a good job.
But I've been waiting to see if you suddenly see Busby or Cogdill or Mitch Little come swooping in to rescue the defense lawyers who have struggled with some of these witnesses.
I think of the three, Allison Collins was probably the most effective on the defense side today.
Okay. I want to go back and talk about, because I think it was, and I think we all agree that it was pretty powerful when Dutko is questioning. Let me go back into my notes. The HR guy, De La Garza, about the firings, the Whistleblower Act. And I started to read this email from this employment law attorney while they were
Oh, yeah,
a
that
minute
was
ago,
good.
and I thought this was just fascinating what she had to say. Let me pull this email up. She said that De La Garza did not provide a complete current definition of at-will employment. That doctrine has existed since 1888 based on a Texas Supreme Court decision in East Line and Red River Railroad versus Scott. A reason that has to do with the reasoning that when neither party has expressed a period of employment, either party may terminate at any time. And she says that when that ruling came down in 1888, there was no whistleblower or anti-discrimination laws. Currently, and this is quote, currently an employer cannot use at-will status as an absolute right to terminate, all in caps, if the termination was for an illegal reason, i.e. whistleblower retaliation. Timing is also an issue. If an employee blows the whistle and then an employer suddenly, quote, finds, end quote, reasons to terminate, such conduct starts to smell more like retaliation than a legitimate reason for termination. Using an, quote, insubordinate, end quote, tone doesn't smell very good.
I agree with that. I think that's a very good analysis. I think when you have 8 people go to the FBI and then suddenly all of them are gone within 30 days, 40 days?
Within 6 weeks, a combination
Yeah, I think it was about a month and a half, right?
Yeah, so September 30th of 2020 is the day they go to the FBI, and that is the day, let me see. I believe September 30th is the day they got wind of the second bank subpoena. I think the first bank subpoena was the 29th, but the 30th is the day they go to the FBI. October 1st, they notified HR and the Attorney General. October 2nd, Penley and Maxwell are put on A-time. October 13th, Maxwell files a formal complaint. October 14th, some of the others file formal complaints, and then 19 days after they go to the FBI, you start to see firings, and then we got people fired November 2nd, and I mean, just a combination. So pretty quickly, you got people being fired.
Well, I'll just point out that these 22 Republicans in the Senate are all conservatives who are not generally supporters of organized labor, and like the idea of themselves led arguments about Texas being an at-will state, and they're probably not in love with the whole idea of arguing based on labor law or protecting labor. So arguing the nuances of firings probably doesn't go over well with the Republican majority.
No, and I think that when you're a conservative on the right, that you are a rule follower. I mean, you believe that rules exist and the laws exist and you're supposed to follow them. And firing people based on whistleblowing is against the law. You can't do it. I mean, you open yourself up to civil litigation, which obviously happened. I would be interested, and I don't know if anyone ever looked into this, was anyone else fired from the AG's office in those 6 weeks?
Besides the whistleblowers?
Mm-hmm.
I don't know.
I just would be curious to know if these were the only people fired. But it was only 6 of the 8, right? Because didn't 2 resign?
Let's see.
I mean,
Right.
1.
6 are the whistleblowers.
A couple of them resigned, and I'm
2
losing.
of them.
Mateer resigned.
Okay. They took all his duties away, right?
I don't know.
Somebody said they resigned.
There's people that lost. If they start to kind of run in my head,
Yes.
and I want to be careful about what I say about each
Yeah.
one because But I know Mateer resigns, and then you have some people like Brickman.
Brickman's a whistleblower.
And he's fired, but he's basically told, you can resign or be fired, and so they fire him. That's what he testified to yesterday.
I thought Mateer, Bangert, Vassar, and Brickman were the whistleblowers.
Well, whoever were the whistleblowers that got fired, I'm just curious if anybody else was fired during that time. But, I mean, it really defies belief that educated attorneys are sitting around the AG's office thinking we can just come up with HR reasons to fire these people. Probably it's all going to be okay. And Would love to have been a fly on the wall during those conversations of how they're going to justify firing all these people.
Well, and they wrote a memo.
Yeah, they did write a memo.
And the Third Court of Appeals didn't. Well, the Third Court of Appeals dealt with the question of whether or not an elected official was subject to the Whistleblower Act. So Jay's going to bring up this, and I want Bud to kind of talk about it. He's going to bring up what it takes to convict or not to convict.
The numbers?
Yeah, and he doesn't really like the word convict, actually.
I had the numbers. Well, it's we're not convicting anybody of anything here. There's nobody on trial or facing any allegations. It votes to sustain articles of impeachment.
What are the colors?
What we're discussing here.
What are those colors?
But these are basically, so you have 31 senators.
Okay.
You have the 12 Democrats that we are likely to vote in favor.
Okay.
And then what has to happen in terms of with the Republicans, one way or the other.
You have to have 9 Republicans who vote with the 12 Democrats in order to get to 21. So you see the 9 Republican blocks that are purple there. They have to vote with the Democrats in order to remove Ken Paxton as Attorney General. The presumption is, based on the pretrial motions, there were from 6 to 8 Republicans who voted to continue with the trial. So you believe going in that there are from 6 to 8 Republicans who are in those red seats, that probably more once the trial's over would be in those red seats and would be in favor of keeping Ken Paxton. The number that he's looking for, it takes 21 in order to remove it. 20 to 10 vote means that the articles fail, the motions fail. It takes 21 in order to remove him from office.
But you basically said, Bud, this morning that you feel like there's not the votes to sustain.
I have said all along that I did not feel like there were the votes to sustain the articles of impeachment. I felt like going in that it was within a vote either way, and that the trial might push a vote one way or the other. It would be a question of whether the prosecution brought such a strong case that a senator would feel confident going back out for re-election and saying, well, now look at this case. If there was so much attention brought to it and so much thorough feeling of wrongdoing that the voters themselves were convinced, then another senator might feel like they could go out and vote for removal. I'm not sure that's happened. I still think it's within a vote either way. I think it could be 20, it could be 21, and I think that really is still up in the air. I think that there are times going, at the beginning of the trial, I thought early in the trial, I thought that the prosecution was making some headway and might have gotten that 21st vote, that 10th Republican, and that 11th Republican, and then I thought, well, maybe not. That maybe they've lost some ground. So,
well,
it only takes 10 Republicans to save Ken Paxton.
Well, and keep in mind that in a criminal trial, you're not going to have people tweeting their support of the defendant to get to the jurors. You're not going to have phone numbers of jurors put out for people to call their offices and try to pressure them, and you're not going to have threats of running people against them in the primaries if they don't vote the way you want. That doesn't happen in a criminal trial, which is another reason this is such political theater.
And there is a political element to it of opponents, but I don't think most of these senators are very worried about an opponent. They have the incumbency, they have the strength of being incumbents. It would take a really well-known challenger to unseat an incumbent.
Oh, yeah, and money.
And considerable amounts of West Texas money. That money's going to be there, but the candidate may not be there. So I don't think the concern about the challenger is that strong, but it might swing a vote one way or the other. I was going to talk about the term rhino.
Let's talk about it.
That was good.
Some of these questioners, they've started out right away and said, "Are you a rhino?" And that's been one of the direct questions. And everybody talks now about, "Are you a rhino?" Donald Trump's message on social media said, "Oh, these rhinos." Donald Trump has made the term rhino mean anybody who's against me is a rhino. It's kind of replaced the never Trumpers.
Right.
Now the people who used to be called never Trumpers are called rhinos. The term rhino first appeared in the 20s of the 20th century, in the 1920s, in the Manchester Union Leader, was one of the most conservative papers in the country throughout the 20th century, referred to some rhinos there. But then it really wasn't in common use. In the 60s and 70s, we talked about the Rockefeller Republicans in the party. They were the business Republicans. They were called the Country Club Republicans. They were the Rockefeller Republicans. And then it was not until the late 90s and the Clinton administration, after the Contract for America, after Republicans had started using the rallying cry that the pro-choice movement is baby killers, after that kind of language was used, that Republicans started attacking everyone, first of all, if they were in favor of abortion rights, something that doesn't exist in the Republican Party anymore, then they were rhinos. Or if they were in any way willing to negotiate with Democrats or work with those baby killers or even compromise with those baby killers, then they must be rhinos. It rose again in the 90s in the California Republican Party and then became applied nationwide. And so you went on, you had people like Speaker John Boehner and Mitch McConnell today, and of course Mitt Romney, the various Republicans who've been labeled as rhinos over the years because they didn't toe the line of either the party platform that was written in the state level. The party platform is written by those few hobbyists who make their point to go to regional and state conventions, without really any input from anyone else. They go down and make things up, and then they think that everybody else should follow the things that they went off on their own and made up. The strain between elected Republicans and the delegates was so strong that last year Governor Greg Abbott didn't even speak to the state Republican convention. He held a reception of the party across the street because the state Republican the actual members of the party, the delegates, are so hostile to elected office holders that they don't even socialize with them. They don't even get involved with them anymore. But the term rhinos now, Donald Trump made it in 2016, made it into an across-the-board term for everybody who's against me. And this is part of the new loyalty oath that the Republican Party preaches, is that you're either for Trump or against Trump. You have to be for Trump all the way and do everything for Trump, whether you think it's legal or illegal, whether you think it's right or wrong. You must be for Trump. And that we see this same kind of argument in the Ken Paxton defense, that when the lawyers say that they didn't work for the state, they worked for Ken Paxton. You see this kind of idea that somehow the loyalty to the office holder is more important to than the loyalty of the people. But Donald Trump's appropriation of the term rhino and making it into something, which is really ironic, because Donald Trump himself was a Democrat until 2009. He was a registered Democrat, and so he's only been a Republican
and a donor.
now. What's the what's the math on that? 14 years.
Right.
He's been a registered Republican, but now he can determine who is a rhino, and so he's used the term rhino to mean they're against me, and he labels everybody else, all the people we used to call never Trumpers. Now you're a rhino, and now we see all of the great echo chamber on social media using the term rhino too. The social media commenters, many of whom are paid, we know, $50 a comment. Some of them, we see all of them echoing that if you're against Ken Paxton, it's all the rhinos and the terrible rhinos who are trying to get rid of them. Rhino, rhino, rhino. And so it's become a very different term even than it was in the 90s or the 2000s.
Well, what's interesting in this case is these so-called whistleblowers, and I don't really like calling them that, but just the group, the fired ones or whatever, are some of the most conservative people you're ever going to find. So to label them rhinos is actually kind of funny, because it's ridiculous, it's absurd. These are not Republicans in name only. These are very conservative, right-wing Republican people who are the ones that are lost their jobs, went to the FBI.
It's almost like the world's a little bit upside down.
It's extremely upside down. I mean, it doesn't matter for any particular purpose, but I mean, I'm a I'm a Reagan big tent conservative. I have been for many years, ran as a GOP candidate multiple times in Dallas, and was president of my Republican Women's Club like 4 times. And I guess maybe I'm a rhino. I don't know. Maybe I am. Today I would be.
And women's clubs, and Republican women's clubs in general, are suspected of being rhinos and have been threatened with, removal from the party because they're not going along with the more manly leadership that some of the candidates want. We've had Republican candidates who said that only men should be elected and things like that. But the whole use of rhino has changed. Certainly, the business fiscal conservatives, are being labeled as rhinos even when they're the strongest fiscal conservatives. And then you have some of the there is a division in the faith and values conservatives. There are the strong Christian believers who believe that for all Donald Trump's or Ken Paxton's flaws, they are leading America to be more Christian and to be ruled by Christian faith and values for all their personal flaws, that they're anointed by God to make the nation and the state more Christian. Then you have another set of Christian believers who believe that the way to lead people to Christ, to win souls to Christ, is to model Christian values and Christian beliefs.
Christian witness?
And they believe a Christian witness, that these are not, that Ken Paxton is not a valuable Christian witness. And so Dan Patrick has written a religious book. I mean, you have many people of deep faith in the Texas Senate, and you probably have some who fall in both categories of the Christian faith movement currently, the religious conservative movement. The faith and values conservatives who are not so on board with the whole Christian domination policy believe in a more of a Christian democracy where Christians are elected, Christians win elections fairly, Christians pass bills with fair representation for everyone, and all religions are included, and America's a nation for everybody. And so you really have this division over whether Christians should boss everybody or lead everybody.
Well, interesting to look ahead to closing arguments. I'm going to be fascinated to see who argues, because there have been so many lawyers involved on both sides.
You mean who does closing arguments?
Yeah, who does the closing argument for each side? I'm sure they'll probably split it up, which is normal, which is you get allotted X amount of time and one lawyer does this portion, another lawyer does this portion. But with this many lawyers, and I think you said they were only getting an hour.
Yeah.
Is that right?
For closings, yeah.
It'll be interesting. Some of them are probably very good orators and might be more interesting to listen to. So I'm excited about closing arguments. I would like to hear. I'd like to hear a bit from Rusty. DeGaren's really good at closing.
It'll be interesting to see who bats cleanup for both sides.
Yes.
I mean, it feels like for the defense it will be Busby. It's hard to imagine Busby giving up the closing.
He's getting the big check.
He probably wouldn't do all of it. Maybe he'll break it up. I mean,
and I think for Hardin, for the prosecution in the same way.
That'd be good.
Because he's there to appeal to the senators.
And you've got to go through each, and it's a lot to do in an hour, but you've got to go through each 16 of them, and you've got to say, we proved it with this and this and this testimony and this evidence, and then the other side's got to do the same thing and say, and they didn't prove it because of this and this and this, and that's how it works.
Do you have closings already written at this point?
When I try a case, I usually have a theme that I carry throughout the whole trial, so I know where I'm headed. So I know what I'm going to be doing at the end. Now, trials are easy to prepare for, but when you're trying a case, it can all fall apart. Like, you can have a theme and then things happen, people say things you didn't expect, all kinds of things can happen, and you have to sort of change your theme. That's happened to me before. But generally speaking, I would say I have the basic outline of what I'm going to say at the very beginning.
So let's talk about that. So
what do you say?
Theme, let's start with theme for the prosecution.
Theme for the prosecution, I think, is going to be kind of what I just described, where you're going through each one, and I would do a lot of visuals. I might even have a photograph of each witness and how they proved, what evidence they gave towards that particular article of impeachment. So, because there were a lot of people testifying, and you can tell by the way this room is laid out, in a normal trial, the jurors can see each witness because they're really close to them, but you see how far away all the seats are. If you're in the back, you maybe didn't see them very well. And so I would like to have a little photo of each witness and their name and a little summary of how I think they added evidence to prove that impeachment, and have a lot of visuals, kind of like the timeline you said, how powerful the timelines can be. Kind of an infographic of each one of the impeachments, I would think would be a very good way to go. And then
Theme for the defense?
it really is going to depend on who is doing the closing arguments. If it's Busby, you know, there's going to be a lot of stomping and yelling because that's kind of his bombastic style, which has worked very successfully for him in his career. And lots of probably sarcasm and this is ridiculous and all the kinds of things we heard during his cross-examination. And then he's probably going to get up and say, in this article, they didn't even come close to we can just throw this one out. They didn't even come close and do a lot of this dramatic stuff.
Right, because that's
I'm
kind of par for the
expecting
course.
Let's just throw this one. Let's just throw this one. Let's go to this one. They didn't throw this. Let's throw this one out.
He's got to do 16 of them.
Yeah, I think
Maybe he'll
it
have
has to be
16
kind of
pieces
fun.
of paper or something, you know?
You know, he's a very dramatic guy. I expect it to be fun.
You know, one of the things we were talking about yesterday with Victor Vital is that, you know, all this, you know, rules of evidence, and I mean, because I've watched a lot of trials, but it's pretty rare to have, you know, lawyers, you know, subsection this of rule T, blah, 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 blah.
Yeah.
I mean, almost like, is this going to be played in law schools, like a legal clinic?
Well, Erin should be, because I'll tell you what, she was ready. She was ready for objections more so than, you know, just about anybody else. She was really ready.
She had her rules down.
But the guy today, what was his name?
Dutko?
Yeah, he was really good too.
I noticed
he was
somebody
making good
tweeted and
objections.
said, I want to go out and commit crime just so Erin can defend me.
Oh yeah, she's excellent.
Bailiff can
Very
bring in the
impressive.
witness, please.
Oh, here we go. We're back in.
Bailiff can bring in the witness, please. We have all the jurors. Mr. Asso is the correct pronunciation. I want to be sure I have that right.
Thank you, Judge. Mr. Dorfman, we were just talking about the effect that a plea to jurisdiction actually has on the discovery in the case. Now, I want to focus, Eric, if you wouldn't mind focusing on the next page, top paragraph, which is the bottom paragraph of Article, bottom paragraph of Article 8. I want to read that to you. Testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. Now, throughout the course of the lawsuit that the whistleblowers filed, are you aware of whether specific facts or allegations became public? And could you turn your mic on, sir?
Better?
Okay, I'm going to re-ask that question.
Please.
Were you aware of whether the specific facts or allegations with regard to the whistleblower suit became public?
Yes.
Can you tell us about in which ways, if you know, they became public?
Well, we talked about that earlier before I came to interview at the office. There were news stories that contained allegations made by the whistleblowers. It was about that same time, maybe a little later, that the lawsuit was filed. That was a news story and a very detailed state court petition that's public record, public filing, covered in the press accounts. And then I think they amended that petition twice between the original filing and early February. So there was a first amended maybe in December, and then in February, just before the plea of the jurisdiction hearing and the temporary injunction hearing, they filed a second amended petition, which I think is the last one. But that's 63 pages, very detailed allegations.
And I'm going to stop
record.
you real quick just to clarify. When you say they filed and amended petitions, can you talk to us a little bit about, well, who filed those petitions?
The four plaintiffs through their lawyers.
So David Maxwell, Mark Penley, Ryan Vassar, and Blake Brickman?
Yes.
And did those petitions include specific facts that they were alleging
Yes.
Attorney General Paxton and the Office of Attorney General committed?
Yes.
Okay. And those pleadings were actually available to the public, correct?
Yes.
You can look them up online?
Yes.
So, Eric, if you don't mind going back one page to the bottom paragraph, bottom clause. Article 8 alleges that Paxton entered into a settlement agreement with whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts. Is that allegation true?
No. Can I explain?
Please do.
The settlement agreement didn't stay the wrongful termination suit. It was on appeal, and our petition for review was pending with the Supreme Court of Texas. That court doesn't have to take any case it doesn't want to, so you have to convince it to take the case. We had made a case. Filed 2 briefs to do that.
I'm going to stop you because we're going to get there, and I want to break that down.
Sorry.
But with regard to conspicuously delaying the discovery of facts,
The settlement agreement didn't do that.
and weren't the facts available to the public at this point anyway?
More than we discussed. Obviously, the petitions I mentioned, but the Court of Appeals decision is 30 pages and has bullet point block paragraph recitals from the pleadings. So it was restated the most serious allegations that the complaints, the petitions made, were restated in the Court of Appeals decision, which also garnered news attention when it came out.
Right. And you had talked about, I think, opposing counsel actually held up a document that was the Third Court of Appeals decision against the Office of Attorney General in this case, correct?
I'm sorry, what was your question?
Essentially that the Third Court of Appeals ruled against the Office of Attorney General.
Correct.
So you filed what with the Supreme Court?
A petition for review, an appeal, notice of appeal of the Third Court's decision with a petition for review asking the Supreme Court to take the case.
Can you explain to us, I deal predominantly with criminal law. Can you explain to us kind of how the process works when you file a petition for review with the Supreme Court of Texas?
It's in the form of a brief, very much like what we would call a merits brief, but it's not. It is simply an argument for why this case is sufficiently important to be one of the 100 or 110 cases that the Supreme Court can take from the entire state and rule on. They only hear so many oral arguments or take so many cases. So you have to convince them this is worthy of their attention. We tried to do just that.
Okay.
Our opponents filed a brief between our initial and reply brief explaining to the court they should not. They should let the Third Court of Appeals case stand, in which case the case would have then gone back to the trial court.
Okay. And so the Third Court of Appeals ruling was actually up for appeal, right?
Yes.
Was that ultimately ruled on, that appeal?
Not to this day, no.
Okay. Can you talk to us, are there certain sessions or time periods where the Supreme Court tends to hear cases?
I think that's right. I would defer to people, bless you, who argue in front of the Supreme Court for a living, but yes.
Okay. Do you feel that I guess at any time the Supreme Court can pull your case out of a hat to hear it, right?
I think that's right. They usually confer as a body, I think in person, although maybe by remote sometimes too, especially during COVID.
Okay. Does that have an effect on your ability to negotiate or work out a settlement with another party? Or does it affect the other party's maybe goal or them wanting to settle?
I don't know what the what is in your sentence.
The potential for the Supreme Court to pull your issue out of a hat and have it come before them.
Absolutely. It's a significant moment in a case. If they take it, I think the conventional wisdom would be they're not taking the third court's case if they decide to take it to affirm it, because they could just do that by denying the petition for review, save themselves time.
So what does that mean to you in the event that they might decide to take your case for review?
It would have altered our assessment of the case and made it, we would have felt very good about our chances for winning the appeal and dismissing the case outright.
Would that give you the upper hand potentially in settlement negotiations?
So much so that it might make settlement impossible.
Okay. Do you think, if you know, that had any effect on this case coming to a settlement, or at least settlement discussions starting in this whistleblower lawsuit?
I think that's why settlement negotiations started.
Okay. About what time did settlement negotiations actually begin in this case?
I'm not sure whether it was the very end of December or the first week or so in January of 2021, but about somewhere in that time.
2021 or 2022?
Sorry, 2023. December 2022 and January 2023. Thank you.
And just to clarify for the senators, the petition for review probably sat with the Supreme Court for quite a while, did it not?
Yes, I think we filed our initial petition, initial brief in July of 2022.
Okay. Who reached out to who to discuss settling the whistleblower lawsuit?
They reached out to us, my recollection.
And when you say they, you mean the whistleblower's attorneys?
Yes.
And can you talk to us about when, if you know, when that occurred?
Like same time, late December, early January of 2023.
And what did you do in response to them reaching out?
We discussed internally whether we wanted to, as they were requesting, go to mediation with a professional mediator in the Austin area.
What kinds of things were you discussing within your office as to why or why not settle a case?
We certainly wanted to discuss the pending petition for review and when it might be ruled on and what that might do to the party's willingness to mediate at that point if it happened. Whether we could get a professional mediator worth his or her salt on that short a notice, because I think the plaintiffs wanted to mediate in the next 7 to 10 days, maybe 14 at the outset, at the latest, because they were concerned that the Supreme Court might rule, and either way it ruled, the other side would feel good and the other side would feel bad and maybe couldn't. So risk creates settlement potential. So that would take out some of the risk.
Risk for the plaintiffs, right?
Risk to the plaintiffs that the court would grant it, and that might indicate their case was going to be dismissed maybe in a year, maybe in 9 months. They may have assessed it differently. That's how I would have seen it. And risk for us that if the court declined to accept our petition for review, the third court ruling stands, and we're back in trial court, and we have years perhaps of lawsuits and appeals, litigation and appeals, and the accompanying expense and time.
Who found the mediators?
The plaintiff's lawyers did that. I remember clearly because I was very skeptical that on that short a notice we would get any good mediators, and they told us in response to that, I think, that not only they had 2 or 3 who had available dates in the next week or 2, which indicated to me, I told people at the office, that's a good sign that they're eager to mediate, because they must have called 10 or 12 people if they could find 2 or 3 available on that short a notice.
Okay, so it appeared to you that they intended to reach a settlement with you?
I think they were highly motivated to settle.
Okay, and that's based on your years of commercial litigation experience, I assume?
And as a mediator and trying to get a mediator on short notice.
Fair enough.
In fact, that was kind of my specialty, is I didn't mediate full time, so if parties couldn't get one of the regular mediators, they knew I was probably available.
Now, I want to zoom out a little bit, just generally speaking, in your years of experience as both a mediator, a judge, and a litigator. Does a party's willingness to settle a case indicate that maybe they think they're liable or that they think that the other party is correct? Can you talk to me about that?
Sure. In my experience, especially mediating and representing parties who mediate their cases, both sides at least will say they like their case, and they frequently do. Mediation takes place when there's risk and uncertainty, and the only way to control the outcome is for the parties to reach an agreement and take it out of a jury's hands. You never know what a jury's going to do. You don't know who the jurors are. And it may be 2 years from now. It may be, again, 12 people pulled off the street. That's, if you want to subordinate your control of your affairs to those people, that's your choice, but that's expensive and risky.
Okay. And I'm
not sure I answered your question. Did I answer your question?
You answered my question. Okay. I appreciate it. And I want to bring actually your answer and apply it to the fact of this case. Did you have a conversation, without getting into specifics, with other OAG employees about settling or at least going to a mediation with the plaintiffs in this case?
Oh, yes.
Okay. Now, when you entered those discussions, did you have a viewpoint on the strength of your case for the defense, the Office of Attorney General in this case?
Yes.
And what was your viewpoint?
Well, we hadn't probably looked at it in some time since filing the briefing, so we reconvened, revisited, reminded everybody where things were and what the arguments were so we could assess that. I remember being a voice, as I am generally and maybe professionally. Look, let's go to mediation compared to years of trial and discovery and outside counsel on both sides. The expenses, the time is short. We can do it in a day, maybe two. And the expenses, a rounding error in the budget, it's the responsible thing to do, especially in this case. It's one thing if you're a private plaintiff or a defendant. It's another when you are dealing with the state's money. I think I felt and articulated that we kind of have a duty to explore settlement. Maybe it can't happen, but we should give it a try.
Right. Your Honor, at this time, may I approach the witness in the court and opposing counsel? Thank you. Mr. Dorfman, I'm showing you what's been pre-marked as Attorney General Exhibit 335. Do you recognize this document?
Yes.
And what do you recognize this document to be?
This is an internal memo prepared by Chris Hilton, the chief of our General Litigation Division, assessing after we'd received settlement statements from, I think, 3 of the plaintiffs in the Whistleblower Act case, explaining why they thought their case was strong and what they thought they would recover at trial.
And let's not talk about the contents of the document, but could you tell me when this document was authored?
This, on its face, it says February 1st, 2023. I don't have any reason to doubt that's the date. That's the date, by the way, we mediated the case. Okay. So whether it was circulated before that date in draft form, I think it was, my recollection. We certainly discussed the contents of it internally before it was put into final form.
Okay, and did the findings, without getting into what the findings were or the subject matter of the document is, did this have an effect on your mindset going into the negotiations?
I don't know if it certainly informed me, and I relied upon it and had, I think it summarized the state of play well.
Okay. And is AG Exhibit 335, is that a fair and accurate copy of the memo that you received from Chris Hilton?
Give me 1 second. Sure. Yes.
Your Honor, at this time, I would offer AG Exhibit 335 into evidence.
Any
Mr.
objection?
Ross, I just want to make sure I have the right document. Is this the one with the AOG seal, but with Ken Paxton's name removed?
Yep, that's it.
Then no objection.
Admit
May I proceed?
335 AG Exhibit into evidence. You may continue.
Thank you, Judge. Now, I don't want to go line by line in this report, but would you mind just summarizing the kind of what this document is and what you and Mr. Hilton's thought process was with regard to the financial aspect of this mediation in the case?
Sure. It's important to realize the mediation, we were told in no uncertain terms, Blake Brickman would not participate in mediation. He would not come to mediation. He would not be there. He was going to trial come hell or high water. So the opportunity was to settle with 3, not all 4 of the whistleblower plaintiffs. And this, so we received settlement statements from demands, basically. This is what we're going to present the week before, maybe a few days before the mediation date. And this was kind of a summary. I think collectively their attorneys argued for over $5 million in damages if they settled today. Of course, prejudgment interest and attorney's fees, as they said, would go up if the case continued, et cetera. But so for 3 of them, that was and we didn't want to take their word for it, so we asked one of our top attorneys to read those carefully, review the case law, and report back on what we would consider a more realistic assessment of the case's value was.
Okay. And just a brief question. This is just an inter-office memorandum, right?
Yes.
Objection leading.
Was this?
Overruled.
I'm going to ask the question again. Was this an inter-office memorandum?
Yes.
Did you send this out to anybody outside of the Attorney General's office?
No, we would not have done that.
Did you represent that you were the Attorney General or that you had the authority to act without Ken Paxton's, I don't know, authority in this document?
By this memo?
Yeah, by this
No.
memo. No, okay. So, can you tell us whether or not you felt that there was an ability to potentially save the state of Texas, the public of Texas, money by engaging in a mediation and potentially a settlement?
Well, I certainly thought that was the case. Otherwise, it wouldn't have been advisable to go to mediation.
Okay. Now, which specific plaintiffs in the whistleblower lawsuit were involved in the initial willingness to settle or request to settle the case?
Ryan Vassar, Mark Penley, and David Maxwell through their attorneys. I don't think we ever talked directly to them during this process.
What about Blake Brickman?
Well, as I said, Mr. Brickman's attorney told us, and actually the attorneys for the other 3 plaintiffs told us, Blake Brickman will not come to Austin. He will not participate in the mediation. He doesn't care. He wants his day in court.
Did you have a reason or idea as to why Mr. Brickman wanted his day in court?
Yeah, well, this is secondhand, so I understand Mr. Brickman is financially secure.
Objection hearsay. This is secondhand.
Sustained.
Your Honor, I'd actually argue that it goes towards settlement agreements in this case, and under 408B, it should come into play.
Then my objection is 408. This goes to settlement, and it's also hearsay.
Which is if 408B is the exception to the rule, and
We've had this discussion on, I think, yesterday or the day before, so I sustain the objection.
Yes, Judge. Needless to say, Brickman's not there, is he?
Wasn't there, wasn't going to be there. Well, and I say wasn't there. We didn't anticipate this or plan this, but February 1st, the date we set for the mediation, ended up being the winter freeze.
Did Mr. Brickman's attorneys come to you with additional demand? Well, we'll get there. Talk to us about how the mediation went. What day do you recall you started mediation?
I believe it was a Wednesday, February 1st. And we had planned to be in Austin in person at the mediator, Patrick Keel's, former judge, office. As it happened, with the freeze set in, I stayed in Houston, and we were all on a Zoom.
And Mr. Dorfman, it's been a few years. Is it possible that the dates
Might not have been a Wednesday.
Fair enough. Judge, may I approach Mr. Dorfman?
I think it was a Wednesday.
Was this a one-day mediation or a two-day mediation?
Ended up being initially planned to be one day, February 1st. We ended up, I think, on February 8th having a second day by agreement with the plaintiff's attorneys.
Okay. Can you talk to us, and we'll get to the document in a second, but can you talk to us about how the first day of mediation went?
It went long. I think we broke sometime around midnight. I want to give Patrick Keel all the credit in the world. We didn't know until it started turning dark that he didn't have power in his house. And at some point, he was on his laptop and lost that power, couldn't recharge, so he's now on his phone on the Zoom call.
This is all happening online, right?
All happening online till midnight, and I think his juice gave out at some point.
Was it a good day of mediation, or was it a bad day of mediation?
I didn't have a whole lot of expectations that this would settle. It didn't, obviously, on that first day, but we got real close. And again, we came in with the expectation that the option today is to settle with 3 plaintiffs. Sometime between 5 and 6 p.m., Mr. Brickman showed up, again, remotely, so I don't know if he was physically present.
Sure. I'm going to stop you real quick. Was this the first day that it got real close and Mr. Brickman showed up, or the second day of mediation?
First day.
All right. So you guys are making headway. You said Mr. Brickman showed up. Can you talk to us about any effect that only 3 of the 4 plaintiffs were present that it had on you? And then what happens when Mr. Brickman shows up?
Well, I think Mr. Hilton's memo, Exhibit 335, speaks of the fact that it's more valuable to us to settle the entire case.
Okay. And why is that?
Because if we're settling with 3 of them, we're paying money out. Mm-hmm. Yet we still have to pay our lawyers and outside counsel on top of that to go to trial, to go to discovery, all the expense, maybe less time, maybe less discovery because it's just 1 plaintiff, but still time, resources that we would like to save, ideally by getting rid of the whole case at once.
Because what is the point of settling this case to you guys?
We have to be good stewards of the taxpayers' money, of the state fisc. And so we viewed this as any other case. One, that's why I argued for mediation, is we should at least try, if it's cheap and inexpensive to try and settle this and save that money and time and resources. And then settling with 3, I think it would be less valuable, but by the same token, we would offer less money. And I think Mr. Hilton says it in the reverse way in his memo that if Mr. Brickman would come to the table and we could make sure we don't have to expend any money after a settlement, I think his word is that would be worth a premium.
Okay. Talk to us about what happens when Brickman joins the negotiation table. How did that go down? Did you all reach out to Mr. Brickman, or did somebody else reach out to Mr. Brickman? What is your understanding?
I don't recall real clearly. I think it was a surprise to us.
And how did you take that surprise?
Good and bad.
Can you tell us about that?
The good is, look, we've all along preferred to settle with all 4 rather than piecemeal. It's more valuable, it's worth the premium for the reasons Mr. Hilton stated in the memo, the exhibit. So that was good. Bad is, wait a second, you told us all along, all week, maybe 2 weeks now, Blake Brickman's not interested in settlement, Blake Brickman's not going to participate in the mediation, he's not available, he's going to trial. And now that we're talking real dollars and it looks good that we might actually settle, now he's interested. All that, was that posturing? Were we being sold a bill of goods? That the suspicion crossed my mind.
Did you all reach a settlement that night?
No, we got real close, but no.
Now, I want to talk to you about AG Exhibit 423. Do you recognize this document?
Mr. House, be sure you speak up and stay on that mic a little bit.
Yes, Judge. Do you recognize AG Exhibit 423?
Yes, I do.
What do you recognize that document to be?
This is General Paxton conferring on me.
Objection, Your Honor. Testifying from a document, not in evidence.
I'm going to lay the predicate right now, Judge, and I'll instruct the witness.
Overruled.
Without getting into the contents of the document, what do you recognize this document to be?
It's a memo from Attorney General Paxton to me and to Chris Hilton Subject line settlement authority dated February 8.
Okay. And did this email have an effect on your abilities and your thought process when going into the mediation on day 2?
It confirmed what we had discussed internally, yes.
Okay. Did it grant you any form of authority?
Yes.
All right. Is this email that you see in AG 423 a fair and accurate copy of the email that you received from Ken Paxton on February 8th of 2023?
Yes.
At this time, Judge, I would offer AG Exhibit 423 into evidence.
Any objection?
Yes, Your Honor, I have 3 objections. First, it was never produced. Second, it was listed on their privilege log, so it was never produced. And 3, it's hearsay, so it is inadmissible.
I can address the objections. I didn't hear your second objection. Could you repeat that?
Yes, this document was identified on your privilege log, so you never gave it to us. And now you're bringing it to court for the first time and showing it to us for the first time.
Let me address the privilege log first. As an attorney for Ken Paxton, I think at this time we'd be willing to waive any privilege.
I appreciate that, but the fact
I'm not done, and if I could just finish my response, then I'd be happy to be quiet and let opposing counsel go. So first and foremost, as Ken Paxton's attorney, I'll waive the privilege. With regard to hearsay, it's not offered for the truth of the matter asserted. It goes towards the effect on the listener in the mediation the next day. We heard Mr. Dorfman just state that on the record. And his first objection with regard to it being not being on the witness list, or excuse me, the exhibit list, Judge, this is a rebuttal case at this point, and arguably we don't even have to put a case on. Most of our exhibits are rebuttal exhibits, but we did give them a list. I am arguing that this is a rebuttal exhibit, and for that reason, it is not covered by the the exhibit list rule, and it should come into evidence.
Your Honor, may I respond?
Yes, you may.
Just so we're clear, the process that occurred was they produced a privilege log, never gave us this document, and now for the first time they are sandbagging us with this document without giving it to us. As the court is aware, you have ruled several times that documents that we did not produce would not come into evidence. They never gave this document to us. This is the first time we're ever seeing it. If they want to take every document off their privilege log and put it into the record, we're good with it. Otherwise, we have a valid objection. Second, Your Honor, it is clear hearsay. There is no business record. The predicate laid was not the standard for hearsay, and so it is inadmissible on all of those grounds.
If I, and just brief, yes, Judge. Well, I'm not aware of a privilege log that we came up with or provided to the House Board of Managers first and foremost. This was on our 4th supplemental notice of the exhibit list. I think the court is aware that the managers have given us plenty of exhibits throughout the course of this trial. I mean, if I remember correctly, Mr. Bangert dumped phone text messages between him and the Attorney General during the middle of trial. So to say that I'm sandbagging them is just simply not an accurate reflection of what's going on throughout this case or with regard to this exhibit.
Okay. I've heard both arguments. Give us a moment.
Deandra, just react to this.
Well, once again, we're in a situation where you've got a hybrid proceeding that's sort of part criminal, part civil, and
Part whatever.
part just made up. And so, but apparently part of the rules were that you had to turn over what you were going to have to the other side. And if they had a privilege log and this document was on it, and then now all of a sudden they're pulling it out and trying to admit it, I mean, I don't know what these guys are doing. And also, this witness is just so boring. I wish they would move it along.
Yeah, this witness, well, and you know, I actually covered the settlement situation, and my recollection, based on what I was told back at the time, was that it was actually what Brickman described, that Paxton's side reached out to start the settlement negotiations.
That was always what I heard.
And Dorfman is testifying to the exact opposite. So that's very interesting to me. You know, that's a factual question now. Who started? I mean, because it becomes an important point, right? In a way, because the point that Brickman made of it was that settlement negotiations weren't initiated until after the election. right?
Yes.
And so he's saying the exact opposite. So, you know,
Well,
interesting.
and once again, I go back to the fact that there's pending litigation. These cases are not settled, and to put all this stuff out there in sworn testimony, I just don't think it's a good idea.
Can we settle who started it? I mean, is it going to rest as his word against Brickman against Dorfman? Is there something that's going to resolve that?
I don't know.
We don't know. We'll have to wait till cross to see if the other side has any.
And that could also come
Anything in
out
writing.
I mean, you know, like she said, there's still a pending lawsuit, and it could come out in that lawsuit later.
Well, there's been what I would think or what sounded to me like a lot of disparaging comments coming from some of these AG witnesses against these whistleblowers who have this pending civil litigation against them. I don't know. I don't understand why they're doing that. I would not be touching it. I understand it's an article of impeachment. I just think you could have gone around it without throwing more aspersions on these people, which is what they've been doing.
Well, I mean, they're trying to attack that particular article, and they've been working on it, almost, the whole afternoon and part of the morning. And it seems like that is an article that they feel like is very, very important to them to bring down, and very important to mount a defense against. They're working on the whistleblowers themselves and their credibility.
Oh, well, he's hammering.
Okay, let's take a listen.
Got the big hammer.
Jurors, please take your seat. After consultation with my team here, we will sustain the objection on hearsay. Continue.
Yes, Your Honor. Did General Paxton delegate you the authority to engage in a settlement agreement with the whistleblowers?
Yes,
Okay. Did he do so on February 8th of 2023?
on or about that date.
Where was Ken Paxton while the settlement agreement was going on?
I don't recall. I know he wasn't in Austin, and I believe he was traveling, which is in part why we needed to formalize my authority and the scope in case we weren't able to reach him on short notice if it appeared that we had an agreement subject again to his confirmation.
But to be clear, you guys formalized that delegation of duty, right?
Yes.
Right. So then you go into the second day of mediation, right?
Yes.
Will you talk to us about the second day of mediation?
I believe it was also remote by Zoom, even though the weather had cleared up. And I can't remember exactly when it was we agreed we had a deal, but the same dynamic had played out. Mr. Brickman was participating from the start on the second day at least, and so we were now dealing with 4 plaintiffs rather than a settlement for 3, as we had most of the first day of mediation.
And did you all reach a settlement agreement?
We did.
What was the settlement agreement that you all came to?
And to be certain, I think we reached it that day. It may have been the next morning.
Okay.
Before it was finalized.
Fair enough. What was the settlement agreement?
It was in the form of a mediated settlement agreement, payment of $3.3 million to the 4 plaintiffs in exchange for full and complete releases of liability against the Office of the Attorney General. There was other components we had agreed to, and if you have the copy of it, that might help me, but we had agreed to attempt with ERS to reinstate Mr. Vassar in his retirement plan. I think that was the only fringe benefit that was addressed, but I recall that. And then Mr. Maxwell had a separate F5 administrative hearing case in SOA, State Office of Administrative Hearings, which was abated pending the pendency of the whistleblower case. So that stayed, their filing stayed that proceeding, which was an attempt to reclassify him from a plain discharge to an honorable discharge, without which his employment according to them, as a law enforcement officer in Texas was problematic.
Okay. How did you feel about this agreement on behalf of the Office of Attorney General and the public of Texas?
I felt overall, especially now that it was a settlement of all 4 plaintiffs and the case would not go forward, it was a good assessment of our risk. To be honest, it's more than we would have liked to have settled for. I'm sure it's certainly was less than the plaintiffs' lawyers were telling us they should settle for. So that's probably, again, 95% of mediation settlements fall into that category.
Okay. Now, after this case comes to an agreement, you still have this petition for review in the Supreme Court, right?
It's still pending, yes.
And did you all file any motions with the plaintiff's attorneys in regard to that petition for review?
I think the next day.
Can you tell us what motion you filed with the plaintiff's attorneys in regard to that petition for review?
I believe it was styled as a joint motion to abate in the Supreme Court.
Can you tell us what the joint motion to abate did in this case?
Very short motion. It was simply telling the court, look, we've reached a settlement agreement that's binding and disposes of the case. If the Supreme Court went ahead and conferred and spent time deciding whether to take our case or not and made a decision, they'd be very peeved if they found out later that that was wasted energy on their part. So we didn't want to upset the court. So we let them know, hey, we've reached a settlement. We're going to paper it up and finalize a larger document. It's all the bells and whistles, dot some I's, cross some T's, but you don't need to do anything now, and the parties are jointly asking you to put it aside for now.
Okay. Now, I want you to focus your attention on the article of impeachment that is on the screen right now. And it states, the settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts. Is that true?
No.
Why is that not true?
Well, the plea of the jurisdiction stayed the termination suit pending the Supreme Court. At that point, the Supreme Court's consideration, it didn't, whether it's conspicuous or not, it didn't delay the discovery of facts by settling. There was no discovery ongoing at that time. And the way this is written, it's sort of passive voice. But who's doing the delaying? Is the suggestion here that the whistleblowers, by filing a motion to abate with the Supreme Court, are trying to delay the discovery of facts?
Mr. Dorfman, I don't know. I didn't draft the articles of impeachment. Okay, so I want to move on to who pays this lawsuit. Who pays this lawsuit? Who pays the settlement?
Well, the defendant is the Office of Attorney General. That's the party that would be liable and would pay any settlement. Obviously, the legislature has to fund that. So those.
And why is that? Why does the legislature have to fund that settlement?
Goes back to our discussion about sovereign immunity. You can't sue the state without its consent. And even if you have a waiver of sovereign immunity, like the Texas Tort Claims Act or the Whistleblower Act, and you go get a judgment from a court, jury, verdict, all the way, hold it up to appeal, you have a final, unappealable judgment that entitles you to, let's say, $2 million against any state entity. This legislature, this body, can still decline to pay it. They have to agree.
Okay. And are you aware of whether that lawsuit has been paid?
No, it has not been paid, not been funded.
Now, did you engage, without getting into specific conversations of what was said, did you engage in discussions with the plaintiff's attorneys about getting the legislature to pay for this lawsuit?
Yes.
Were they for or against that?
For it.
Now, were you a part of any specific discussions with any legislators about getting this lawsuit funded?
Yes, I was.
Okay. Can you talk to us, without getting into the specific conversations you had, can you talk to us about who it was that you met with to talk about the settlement?
I think there were 2 separate meetings that I participated in. Other people in our office had more, both on the House side and the Senate side. I recall a meeting with Senator Hughes where we discussed it, and with Senator Huffman.
And so you also mentioned that other people were meeting, or were other people meeting with other legislators about getting the settlement paid?
I believe our head of government relations at the time, Ryan Fisher, and his deputy, Colleen Tran, were having such meetings, formal or informal. and Mr. Hilton, I think, too, had some
And
meetings.
if you know, were the plaintiff's attorneys in this case aware of these conversations happening with legislators?
Absolutely. They were adamant. There's email traffic where they're saying we're not doing enough. We need to do more. This person wants to meet with you. That person wants to meet with you. And we said we're doing our best. We agree. We have obligation to act in good faith and make reasonable efforts. But it's really, you should be highly motivated to do what you can and have the meetings you need to have as well. And we'll show up with you, but let us know.
And just because they haven't agreed to pay it yet doesn't mean they can't at a later date, right?
Of course.
Do you, and you still believe that it is the state of Texas, the public funds that should fund this settlement agreement, right?
I believe that initially. I believe it now if the case goes back to trial, which I think it's settled, but others may feel differently. All the reasons that were there before, again, we'll go back to the Supreme Court presumably, so, but the risk return of time, the certainty of time, litigation, resources, lawyers being devoted to this when they could be doing Biden administration lawsuits or something.
Let me stop you real quick. And just to be clear, you said if the case went back to trial, if the case had gone to trial and there was a judgment entered against the Office of Attorney General, would it still be, should that still be paid from public funds?
That would be up to the legislature to decide.
Okay.
No one can make them.
Would Ken Paxton ever be personally liable for that lawsuit?
No, he's not a defendant.
Okay. You were at the Office of Attorney General. You're currently still working there, right?
Yes.
My understanding is you took leave for a little bit of time.
Yes.
Okay. About how long were you gone from the office?
From roughly early May. I returned to work remotely probably around the July 4th holiday.
So just recently, right?
Just recently.
Okay. I want to talk to you about the time period from when you started at the Office of Attorney General in December of 2020 up until you took leave in May of 2023, okay?
Okay.
Can you talk to us about some of the accomplishments made by the Attorney General's office under the leadership of Ken Paxton while you were there?
Well, I've referenced the Google ad tech lawsuit, one of the biggest antitrust cases, not just in the country, but in decades. That's still ongoing.
Objection. I apologize for interrupting. Anything after this lawsuit is irrelevant.
Actually, Judge, if I may be heard on the matter. Yesterday, the House Board of Managers elicited testimony from Blake Brickman. I have the transcript here and be happy to show the court, but they've opened the door to the Office of Attorney General's productivity after this whistleblower lawsuit, after these terminations occurred. They talked about the fact that there was not productivity and that the office wasn't functioning well. As a result, they've opened the door. That would leave a misimpression on the jury, and as a result, Mr. Dorfman should be able to talk about how the office is functioning.
Overruled.
So you talked to us about one of the lawsuits. Would you please continue to talk about the other accomplishments and the functioning of the Office of Attorney General?
I should have started with our immigration cases, which I'm probably most proud of.
Would you please tell us about your immigration cases?
Day one, I mentioned this maybe earlier, of the Biden administration, all the executive orders that came out. One was the 100-day moratorium. We were the first to get a nationwide injunction requiring the Biden administration to abide by congressional directive that no, if you have a deportable alien, they must be deported within 90 days, no exceptions. And that we continue to file and challenge and try to hold the Biden administration to the letter of the law and the rule of law on our border. Title 42 is one of those cases. DACA is a continuation of a case then Attorney General Abbott brought years ago against the Obama administration. We just won, I think in the last week, a ruling out of the federal court in Houston that the revised Biden administration DACA policy is just as illegal, unlawful, I should say, as that in our favor.
Okay. I'm going to bring, you talked about big tech already. You talked about the Google case.
That's one of the Google cases. Another Google case we settled before I took leave. We broke away from a multi-state all the states suing in one location. We broke out of that, filed our own lawsuit in Texas state court. We settled with Google for $8 million when all the other states put together settled for $9 million over the Google Pixel phones, and that was to the relief of Texas consumers who were deceived by misleading advertisements.
Any litigation with regard to opioids?
This is mostly before my time. The money has come in since I've been at the agency, but I can't claim credit. General Paxton himself led the nationwide negotiations on that, worked very hard on that, deserves the credit for that. And it's been billions in money from those manufacturers, distributors, marketers, consultants, pharmacies that were responsible for the opioid crisis that was so devastating.
And so based on what you've seen at the office during your time there, have they been successful in their efforts and their litigation under the leadership of Attorney General Ken Paxton?
I think so. I've been amazed at what we've accomplished. We've worked our lawyers very hard, and they've done very well. They deserve the credit. They're the ones going to court, making the winning arguments and filing the winning briefs, not me. So I don't want to seem like I'm tooting my own horn when I say CNN, no great fan of Attorney General Paxton or our office, had to concede in a news article that Texas had become the legal graveyard for Biden administration policies and executive orders.
Well, thank you, Mr. Dorfman. I'll pass the witness, Your Honor.
Your witness? That sound you're hearing, you have not heard for a long time. It's called rain.
We're sure. All right. Hi, Mr. Dorfman. How are you?
I'm very good, thank you.
I was
The mic's not on, Mr.
Can you hear me?
Yes, sir.
Mr. Dorfman, we were looking at Exhibit 335 that was introduced by your counsel, or counsel for Mr. Paxton. Can you pull that up for me, Stacy? No.
Check your mic one more time. It doesn't sound right.
Is it not working?
No, it is now, but you're tall enough that you're going to have to bend down a little bit.
Yes, Mr. President. Is this the memo that you were talking about on 335 with the counsel a moment ago?
It's one of them, yes.
And this memo was created by Chris Hilton?
I believe so, yes.
One of the lawyers standing over there, sitting over there?
Sitting, yes.
Sitting, yes. When you got this memo, were you shocked?
By what?
By the fact that Mr. Hilton was attempting to usurp the power of Ken Paxton by removing his name from the letterhead.
No.
Did it appall you?
No.
Was it simply a matter of Mr. Hilton picking out this letterhead that is available to every employee of the AG's office?
I think you'd have to ask Mr. Hilton about that. I don't know.
You talked about the internal investigation that was conducted by the Attorney General's office, correct?
Yes.
And you talked about the fact that it needed to be fair.
Yes.
It needed to be unbiased.
Well, it needed to be objective, I think is the word I used.
And the subject of that investigation was Ken Paxton.
One of the subjects of that investigation.
It certainly was a big part of it, right?
The allegations against him were a big part of it.
Your Honor, may I approach the witness?
Thank you.
Mr. Dorfman, I am showing you what has been marked as 524, Exhibit 524. Do you recognize this document?
Give me 1 minute to read it quickly. Can you restate your question, please?
Yes, maybe I can make it easier. You see your email address right there, halfway down the page?
I do.
this is an email exchange that you received, you were on,
Yes.
and so as a result, you recognize this document.
Yes.
And, you know, to use a predicate that's being laid by your counsel, this fairly and accurately represents the email as well as the attachment.
I think that's right.
Your Honor, at this time, we offer Exhibit 524.
Any objection?
Yes, Judge, I'd object to hearsay, and they haven't provided a proper foundation for this witness to sponsor this document.
Your Honor, we have a business record affidavit that overcomes hearsay. That gets by that, and the predicate is this witness was part of this email exchange, is a proper sponsoring witness, testified it fairly and accurately represents the email exchange that he was a part of.
Judge, I'm just confused. I don't have a copy of a business record affidavit.
You do have a copy of the business record affidavit. I didn't hand it to you, but if you want, I can get it for you.
Well, that'd be great. I think part of the rule is that it's, got to be provided to counsel, so that would be good.
I will,
Would you provide him a copy?
yes.
Judge, if I could just have a moment to look at the business record affidavit.
Take a moment.
Thank you.
Your Honor, I assume we're stopping the clock, respectfully?
Judge, I mean, I don't see why it should. They're offering it.
If it's a minute, we're not stopping the clock, but if it's longer than that, I'll stop it.
Judge, I have to reurge my objection. This business record affidavit is not the correct affidavit for these documents. It references Office of Attorney General numbers that are just not contained on the documents that counsel has provided me. And so I can't verify that it's the document that he's purporting it to be.
And we don't have a copy either of the business affidavit.
I can get you a copy.
That would be good. Yeah, it's supposed to be attached so that we know.
I appreciate that, Your Honor. It was attached to a bigger swath of documents. This is just one of the documents that's part of it.
We will stop the clock and give you credit for a couple of minutes here. Mr. Dutko, I will say I stopped the clock, but when either side has not been ready to present us what is needed, we have not stopped the clock previously. So I've given you 2 minutes here, but I don't know how long you're going to take.
Yes, Your Honor.
It does not seem you have your paperwork together.
Yes.
So can we continue and get the clock running and come back to that if you'd like?
Yes.
All right. Resume the clock, resume your questioning.
May I proceed? Mr. Dorfman, when you were on direct examination, you spent a lot of time talking about the fact that the quality of attorney that is currently at the Attorney General's office. You remember that?
Yeah, I think so.
And you said how you were proud to walk through the halls and the lawyers and the high caliber of lawyers.
I don't recall saying that. It's certainly true, but I don't recall saying it.
And you were talking about how good the lawyers are and how hard they work. Do you remember that?
Yes.
Yet, despite the fact that there's the high quality of lawyers that currently exists at the Attorney General's office, Ken Paxton had to hire Louis Brisboe as outside counsel.
Didn't have to, he did.
And it was certainly something that could have been handled internally.
I'm not going to agree with you on that. Now, I have an explanation why.
Okay. Are you aware of the fact that Louis Brisboe has billed the Texas taxpayers $524,000 for the work that was done?
Yes, I am.
And that doesn't bother you?
I think I've been very clear that I view the Texas fisc as a sacred calling for us. That's very important for us to preserve it and spend it wisely. Again, I had a reason why I supported the hiring of Louis Brisboe as outside counsel, but part of the motivation for settlement was to stop paying Louis Brisboe as outside counsel.
Your Honor, we have the business record affidavit that we were going to present to opposing counsel.
Okay.
Is this for this document? Yes. You just got extra copies of VRAs on. Again, Judge, I got to re-urge the objection. The document that they've handed me doesn't have a single Bates label on it, and this business record affidavit talks about Bates label documents. No way for me to verify the validity of these documents.
Your Honor, just so we're clear, these are documents that
Could I have a copy of that?
Yes.
And before you answer his objection, let us look at this. We're ready to resume. I'm going to sustain the objection because we don't find a way to identify this affidavit with the document.
Yes, Your Honor. Remember when you talked about the plea to the jurisdiction a little while ago?
Yes.
One thing is clear, a plea to the jurisdiction stays the case.
Once it's denied or granted.
Right, and so when you filed that plea to the jurisdiction, you, as the Attorney General's office, knew that the case would be stayed.
Yes.
That meant there would be no written discovery.
Yes.
That meant there would be no deposition discovery.
Right.
That means that Ken Paxton did not have to testify under oath for the entire time that that plea to the jurisdiction was being determined.
No one had to testify, yes.
Right, but Ken Paxton didn't as well, right?
Yes. Yes.
And so when you filed it, you knew that was going to happen.
Once a ruling was made, yes.
Right. And even though you lost at the trial court, instead of going back to the case and conducting discovery, you appealed it to the Court of Appeals.
Well, we didn't lose the case at the trial court. We lost the plea.
Right. You lost the plea to the jurisdiction.
We disagreed with that and we appealed it, yes.
Which means that when you lost that case, that plea to the jurisdiction, that meant if you did not appeal it, you could go back to the trial court and take discovery.
If we chose not to appeal it?
Right.
I suppose that's true.
And then you appealed it.
We did.
And lost.
We lost in the third court.
So then, instead of going back to the trial court to conduct discovery, where Mr. Paxton would have to give his deposition, you took a flyer and took it to the Supreme Court.
I disagree with you that we took a flyer. We urged the constitutional separation of powers, which is a pretty important constitutional doctrine. And we also relied on the sovereign immunity of the state, which this body thinks pretty importantly of as well.
Right, and then while the case was pending at the Supreme Court, there was an appeal. I mean, a election, right?
Yes.
And after the election, before the Supreme Court, where you said you had a good faith basis to go, immediately after that's when you guys settled, right?
Not immediately, no.
Shortly thereafter.
We settled 3 months later, a little more than 3 months later.
Your Honor, I was told that the document that was printed for everybody had the Bates label that ran off the bottom, and so now I have a version that has the Bates label that identifies it as a document within the range on the Attorney General's, on the business record affidavit. Since it was a short notice, I have one copy. I would like to show it to opposing counsel and then bring it to the court, if that is okay.
Can I see it first?
Yes, Your Honor.
You can come forward if you like. Come forward if you like. You all can take a stand-up break, but don't leave because we're moving forward.